We'll discuss question number 51, which explain the doctrine of merger in relation to redemption of mortgages. So the very answer we found under section 101, which deals with principle of merger. So as relates to Transfer of Property Act section 101 relates and explains the principle of merger as any mortgagee of or person having a charge upon a movable property or any transferee from such mortgagee or charge holder may purchase or otherwise acquire the rights in the property of the mortgagor or owner as the case may be without thereby causing the mortgage or charge to be merged as between himself and any subsequent mortgagee of or person having a subsequent charge upon the same property, and no such subsequent mortgagee or charge holder shall be entitled to foreclose or sell such property without redeeming the prior mortgage or charge or otherwise than subject thereto as it is defined under section 101 of the Transfer of Property Act as relating to the very doctrine of merger to redemption of mortgages. It is an important principle of equity of jurisprudence that the mere fact of a charge having been paid off does not decide the question whether it was extinguished. It is a matter of intention of the parties. If the charge is intended to keep the charge alive, is presumed whether it is for the benefit of the person paying to do so, for a person is presumed to act according to his interest. This principle of equity, which may be called the rule of intention, is however not applicable whether the person paying off a charge is himself personally liable to pay it, as it was held by Justice M.R. justly as he observed in the leading case, Adams versus Angel, and also in another important concerning topic is the case in a court of equity. It has always been considered that the mere form in which a charge has been paid off does not decide the question whether it was intended to be kept alive or not. The person who pays off the charge may keep it alive or extinguish it, and he may keep it alive either by means of an assignment to a trustee or by a declaration of intention. The intention, however, is always to prevail if it is sufficiently expressed or evidenced by the surrounding circumstances. The equitable rule of intention, as in England, was applied not only to cases where charge was paid off by a person, but also to cases to which the doctrine of merger was applicable. Under the latter doctrine, where a smaller estate and a larger estate in property became united in the same person, in the same capacity, as where a charge holder acquired the ownership in the property or the owner acquired the charge of the property, the lesser estate became merged and the property extinguished is the greater. Equity, however, prevented the merger by applying the rule of intention to such cases also. And as regarding this, in India, the rule of intention was applied even after enactment of the Act of 1882. So, in that connection, we would like to discuss some of the important leading cases decided by the Privy Council. One is Mahesh Lal versus Mahan Bhagwan Das. In by the Privy Council, so Gopal Das versus Punmalha Premukha. In by the Privy Council, where it was refused to extend the rule of intention as laid down in Tolmin versus tear gas. So, in India, the rule of intention was applied by courts in cases arising before the act was passed as being in the consonance with justice, equity, and good conscience. In Mahesh Lal versus Mahan Bhagwan Das, the fact of the case as regarding A took a loan from B in 1872 on a mortgage of Rs 20,000, out of which a sum of Rs 8,000 and all was the payment of an earlier mortgage of 1869 carrying a higher rate of interest. B himself cut off the earlier mortgage out of the consideration amount and got back the discharged mortgage bond. There was no missing encumbrance between his mortgage and the earlier mortgage. So it was held by their lordship of the Privy Council that the question whether a charge paid off was kept alive or extinguished was one of the intention of the parties. That in the circumstances of the case, the intention of the parties was to extinguish the charge, that it was for the benefit of the parties on the date of the advance that the prior charge should be kept alive and that therefore the charge was extinguished as it was held by their lordship of the Privy Council in this leading case, Lal versus Mahant Bhagwan Das. And now we'll discuss about the second important leading case, that is Gopal Das versus Punmala Premukha by the Privy Council. Their lordship refused to extend the rule laid down in Tolmin versus Stier that when a person paid off a prior charge with notice of an encumbrance, he could not keep the charge alive against the encumbrance. Their lordship observed in this important leading case, Gopal Das versus Punmal Premukha Premsuk, that the obvious question to ask in the interest of justice, duty, and good conscience is what was the intention of the party paying off the charge? He had a right to extinguish it and a right to keep it alive. What was his intention? So, as per the old law, extinguishment was the rule and keeping alive was the exception. And as regarding the new law, it is keeping alive is the rule. After enactment of the Transfer of Property Act, so the rule enacted that under Tolman versus Steer that if a mortgagee or charge holder of a property requires the interest of the mortgagor or no, his own mortgage or charge is extinguished unless he expressly reserves the continuance of such mortgage or charge, or unless such continuance is for his benefit. So the authority of Tolman's case had been more than once questioned in English courts and also in several cases before the Privy Council. The present amended section, which abolishes the very doctrine of merger, gives effect to the long course of decisions both in England as well as of the Privy Council. It may now generally be taken to be the intention of a creditor and to his benefit to keep his own mortgage as well as those he paid off alive against subsequent mortgages. Thus, under the old section, extinguishment was the rule and keeping alive was the exception. But under the new section or under the new law, that is the Transfer of Property Act 1882, which provides keeping alive is the rule. So, in that connection, we would like to discuss one important illustration, and in that regarding a first mortgage to B, later a mortgage to C, then B purchases A's interest, and B's mortgage is not extinguished as far as C is concerned. In case C enforces his mortgage, he must pay off B first. So, A mortgage to B, the same property. Later, A mortgage the same property to C. Here B purchases A's interest. So B's mortgage is not extinguished so far as C is concerned. And in case C enforces his mortgage, then he must pay off B. It should, however, be noted that the mortgage is extinguished as between the mortgagee and mortgager. He may keep the mortgage alive for his own defense as against a subsequent mortgage. If the purchasing mortgagee is also the subsequent mortgagee, there is merger of both mortgages. So, if the purchasing mortgagee is also the subsequent mortgagee, there is merger of both mortgage. So, this is the very doctrine of merger in relation to redemption of mortgages as the very principle of merger we found under section 101 of Transfer of Property Act. But before enactment of the Transfer of Property Act 1882, in the old law as it was decided by Justice Amer Jessel in Adams versus Angel, an English case, so also in case of India, Mahesal versus Mahan Bhagavan Das, and also in Gopal Das versus Punmal Premsuk, the Privy Council refused to extend the rule laid down in Tolman's versus Steers case as it was. Relating to extinguishment was the rule and keeping alive was the exception. And under the new law, keeping alive is the rule. So, in that connection, we have discussed one important illustration. So, also the very merger of both mortgages as regarding another illustration, that is A mortgage to B. A mortgage again the property to B. B purchased the right of redemption of A. So the mortgages are extinguished. And if the purchasing mortgage is also the subsequent mortgagee, there is merger of both mortgages. And this is all about the correct and appropriate answer to question number 51, that is explain the doctrine of merger in relation to redemption of mortgages. And in our next upcoming video we'll discuss question number 52, that is define a lease. What are the essential elements of a lease?